Good afternoon, all. Myself, Dr. Neeru Gupta, Assistant Professor, IIMT College of Law, Greater Noida. My topic: a modern approach, law of evidence. Firstly, I am discuss about the introduction of Indian Evidence Act. According to Section 3 of Indian Evidence Act 1872, evidence means and includes oral and documentary evidence. Here, oral evidence refers to all the statements which the court permits to be made before it by the witness, and such evidence should be related to the matter of fact under inquiry, whereas documentary or written evidence refers to all the electronic record presented before the court. Now I'm discussing about the kinds of evidence, two types of evidence, direct evidence and circumstantial evidence. Direct evidence. Direct evidence is considered as imperative evidence for deciding the matter in issue. It directly proves or disproves the fact. In such evidence, a specific fact is established directly without providing a reason to connect to the fact. One hardly needs to point out the illustration provided as the evidence of the witness in court is direct evidence as opposed to a testimony to a fact suggesting guilt. Such evidence is real, tangible, or clear evidence of a fact that requires no thinking or consideration to prove its existence. However, relying on the evidence completely without any reasoning to prove its existence can be considered as a drawback as well. For instance, one may be prosecuted for perjury. Circumstantial evidence. Circumstantial or indirect evidence refers to evidence which proves the fact in issue by providing other facts, that is, indirect facts, and then proving their relevance. A satisfactory conclusion can be drawn from such evidence by relating a series of other facts to the fact in issue. Such indirect fact must have been associated with the facts in issue and have a cause and effect relation. Documentary evidence. Document means, according to Section 3 of Indian Evidence Act, documentary evidence refers to any matter described or expressed upon any substance by means of letter, figure, or mark, or by more than one means which can be used for recording the matter. Such evidence is produced in the form of a document in order to prove a dispute fact. Essentials or subject matter of documentary evidence are as follows: how the content of a document are to be proved, how the document is to be proved to be genuine, how for and in what cases the oral evidence is excluded by documents refers to evidence which the witness has neither personally seen nor heard. It is just reported by the witness and considered to be very weak evidence. In other words, it refers to something that others have said or heard. There are no set standard to receive such evidence provided it has a reasonable credibility and nexus. In the absence of such credibility and nexus, it is difficult and dangerous to act upon such evidence. Thus, such a piece of evidence cannot be used if its credibility is not assured and questioned. The necessity of the rule of evidence. The other one is, if there are no rule at all, then no case will ever be decided. It would take years before the simplest case is decided and justice would become a monarch. Further, if you leave it to the court to decide on each occasion what matters are connected with the matter in controversy and therefore should be looked at certainty as to relevant matter, depending upon the patience of the judge. Therefore, the rule of evidence are absolutely necessary both from point of view of time as well as certainty. The rule of evidence is a part of procedure law. We have gone through the point that rules of evidence are necessary. We have also seen they play an important part in the course of the trial, whether of a civil or a criminal case. Since it deals with the procedure, it is under the category of law referred to as procedure law or adjective. In contrast to substantive law, which deals with right and liabilities, under what conditions a certain right exists in a certain person, Under what circumstances is a person subject to a specific liability? The law of evidence, however, is part of law of procedure, the procedure which a court has to follow. It is said that the law of evidence is the law of form, or the court, or lex ore. It is a matter of convenience, which means in the evidential procedure, the court must follow those procedure of the of the country of the court. The foreigners cannot insist upon their law of evidence being followed by their countries. Now we talk about the functions of evidence law. The law of evidence is of great importance to judicial proceedings. Before are some of its functions. It prescribes the manner in which the relevant facts may be depicted in a court either by way of oral or direct evidence or admissible or hearsay evidence or judicial notice, presumption or documentary evidence. The law of evidence determines what fact may or may not be proved in a court of law. It does this is excluding those facts which may not be proved. The law of evidence elaborately lays down the, the competence, compellability, and privilege of witness. It stipulates rules on who qualifies to be a witness and who does not. It determines the questions to be asked to the witness and the manner of doing the same. The law of evidence also sets down the manner of proof in court by witness or not subject to examination in chief, cross examination, and of judicial notice, presumption, admissible admissions by production of material, object, or documents. Basic concept of the law of evidence. There are certain basic technical terms used in the law of evidence. The meaning of the sum of the terms can be easily understood from the use of ordinary language. Others are silently technical. What follows below in a definition of some of the most crucial terms which are applicable in the day-to-day application of the law of evidence. This list is certainly not exhaustive. Fact. The Kenyan Evidence Act defines a fact. Fact means anything, state of thing, or a relation of thing capable of being perceived by the sense, and any mental condition of which any person is concerned. Fact in issue. According to Section 3 of Indian Evidence Act, a fact in issue means any fact from which either by itself or in connection with other facts, the existence, the non-existence, natural or exact, or of any right, liability or disability, asserted or denied in any suit or proceeding necessarily follows. Therefore, a fact in issue may be a fact that one party alleges and the other party controverts. Relevant factor. A fact is relevant if it has a probability value. That is, if it tends to persuade a court of law of probability or possibility of the alleged factor. Evidence is said to be relevant to a case if it has a direct connection of the fact in issue and can be used to prove or disprove that fact. Prima facie evidence. It is a kind of evidence which normally necessitates a finding that a fact has been proved if such evidence is not rebutted. Direct or indirect evidence is that means of proof which tends to show the existence of a fact in question without the intervention of the proof of any other fact and is distinguished from circumstantial evidence, which is often called indirect. Indirect evidence, on the other hand, refers to circumstantial evidence or evidence of relevant fact which we have already addressed above. Oral evidence. These are statements made by witness in court. It refers to a person's testimony offered to prove the truth of the matter asserted. Intrinsic and extrinsic evidence. It means which is derived from a document without anything to explain it and which is not contained in the body of an agreement, contract, and the like. Parole evidence. This refers to extrinsic evidence and is at times referred to as parole evidence rule. The rule stipulates that no extrinsic evidence shall be admissible to add or to subtract from the content of a written document. Primary evidence and secondary evidence. Primary evidence it also referred to as best evidence. It is evidence of the highest quality available as measured by the nature of the case rather than the thing being offered as evidence. For example, in documentary evidence, if the original document is available, it must be offered rather than a copy of original document. Secondary evidence that which is inferior to primary. Thus, a copy of an instrument or oral evidence of its contents is secondary evidence of the instrument and content. Opinion evidence. This is where a witness is called to testify as to his or her belief, thought, interference, and condition concerning a fact or facts. It is a conclusion formed from observable phenomena and mental impressions. Proved. A fact is considered to be proved when the court, after considering all the evidence after the trials and proceedings, either believes the happening of the case in such a manner as it is expressed, or if the court makes a probable interference beyond reasonable doubt and believes that the existence of the case in which manner as it was explained disproved. A fact is considered to be disproved when the court, after considering all the evidence after the trial and proceeding, either believes that it does not exist as explained, or it the court makes a probable interference beyond reasonable doubt and does not believe the existence of case in such a manner as it was explained. Not proved. A fact is called not proved when the facts are in a circumstantial condition that they are neither proved nor they are disproved. Presumption. Presumption generally means a process of ascertaining few facts on the basis of possibility or it is consequence of some acts in general which strain the possibility and which such possibility has great substantial value. Then generally facts can be ascertained. A presumption in law means interference which are concluded by the court with respect to the existence of certain facts. The interference can either be affirmative or negative, drawn from circumstances by using a process of best probable reasoning of such circumstances. The basic rule of presumption is when one fact of the case or circumstances are considered as primary fact and if they are proving the other fact relating to it, then facts can be presumed as to whether as as if they are proved until disproved. Section 114 of Indian Evidence Act specifically deals with the concept that the court may presume the existence of any fact which it thinks likely to have happened regards being had to the common course, natural event, human conduct, public and private business in their relation to the facts of the particular case. May presume. It is a condition when the court enjoys discretion power to presume any certain few facts and recognize it either proved or may ask for cooperative evidence to confirm or reconfirm the presumption set by the court in its discretion. Section 4 of Indian Evidence Act provides that a fact or a group of facts may be regarded as proved until and unless they are disapproved. The concept is defined under Section 4 of this Act that may presume deal with rebuttable presumption and is not a branch of jurisprudence. Shall presume. It denotes a strong assertion or intention to determine an effect. Section 4 of Indian Evidence Act explains the principle of shall presume that the court does not have any discretionary power in the course of the presumption of shall presume. Rather, the court has a presumed fact or a group of facts and regard them as if they are proved until they are disapproved by the other party. Section 4 of Indian Evidence Act explained that the concept of shall presume may also be called presumption of law and artificial presumption or obligatory presumption and rebuttable presumption of law, and tells that it is a branch of jurisprudence. Conclusive presumption and proofs. It can be considered as one of the strongest. The presumption of a court may presume, but at the same time, the presumption are not compulsory based on logic. Rather, court believes that such presumptions are for the welfare and upbringing of the society. With regards to conclusive proof, the law has absolute power and shall not allow any proof contrary to the presumption, which means if the fact presumed under conclusive proof cannot be challenged, even if the presumption is challenged on the basis of probable evidence. This is strongest kind of all the existing presumption, whereas section 41, 112 and 113 of the Indian Evidence Act and Section 82 of Indian Penal Code are one of the most important provisions relating to the irrebuttable form of presumption or conclusive presumption. Doctrine of res gestae, relevancy of fact. The doctrine of res gestae is expressed under Section 6 of Indian Evidence Act. Fact res gestae means fact which though not in issue are so connected with the facts in issue so as to form a part of same transaction are relevant, whether they are occurred at the same time or place or at the different times and place. Of some essential doctrine of the res gestae, the statement made should not be an opinion or must be a statement. The statement should be made by the participants of the transaction. The statement should have enough information to explain or believe about the incident. The statement made by the person or act of the person should be spontaneous and simultaneous to the main transaction. Now I'm talking about some cases related to the relevancy of facts. Tathan versus Keane. The victim called the police so the help as her husband was holding the gun and was about to kill her, but before the operator could get connected to the court a call and report the statement of the victim, the call disconnect. Later the police found her dead body in her house where from where she called the police for help. Later the police found that the time of the call and time of death was almost the same, so the call by the victim comes under the principle of risk issue. These are the facts of the case written versus Queen. Hence, the court found the husband guilty of murder and questioned his reasoning that he shot accidentally without any intention. Another quotes regarding the relevancy of facts. Uttam Singh versus State of Madhya Pradesh. The child and the victim were sleeping together at the time of incident, and he suddenly awoke due to the voice of X and screamed for the help by taking the name of the accused. Just after the call for the help of his mother, sister, and other witness come there. The court found this evidence to be admissible as to the act of the child, and the accused was of the same part of a single transaction. Now I'm talking about the Section 8 of Indian Evidence Act, which is related to motive, preparation, and conduct. According to Section 8 of Indian Evidence Act, motive preparation are among the first act before any conduct. Therefore, Section 8 explains the importance of motive, preparation, and conduct where there are no direct evidence and the facts are proven on the basis of circumstantial. Kandula Bala versus State of AP is the relevant case of Section 8, motive, preparation, and conduct. The son-in-law before his marriage demanded a piece of land from the deceased. But after the marriage, the deceased refused to transfer the over ownership of the property and expressed that he would give the property to his daughter. Such interference of the father-in-law induced the accused in committing a crime, and after some time, the commenced. The court observed that there is a strong motive with the accused of the committing the crime as the father-in-law refused to transfer the property in the accused name. Conspiracy means few people come together to an act with common intention. So in the same context, a criminal conspiracy is the act of at least two or more than two persons to do an act which is not authorized by the law, an illegal act, or to do a legal act by illegal means. Criminal conspiracy is a kind of partnership in the crime, and every member of such partnership must join the partnership by mutual agreement for executing a common plan. Essential elements of criminal conspiracy under Section 10 of Indian Evidence Law. There should be a reasonable ground to establish the conspiracy. There should be at least two or more than two persons to form a conspiracy. There should be a common intention of all the conspirators. Acts or statement of the conspirators. The act and statement of the conspirator must be in reference to the common intention. Subramanian Swamy versus a Raja, the court in its judgment showed that anything which is doubtful cannot be considered as legal proof, and such proofs are insufficient to prove any criminal conspiracy. Alibi. The word alibi is derived from the Latin word which means elsewhere. Section 11 of Indian Evidence Act explains the concept of fact not otherwise relevant become relevant, makes the provision as a defending ground for the accused. The simplest meaning of this section is a condition when the incident took place and the accused is charged for the incident, then he may defend him for explaining that at the time of the incident he was not present at the location. Although previously it was not relevant for the court to know that where he was, as the investigating showed that he committing the crime, but his explanation that he was not at the place of incident make the irrelevant fact a relevant fact. The important part of Section 11 of Evidence Act is that this rule is only accepted in the course of admission of the evidence, and no other statute provides such rule. Thank you.